Good afternoon, everyone. This is the Tuesday meeting of the House Judiciary Committee. We have an agenda. I think we also have a sheet for people to sign in. Has that been put out for? Okay. If there's anyone who would like to speak on a bill that is on the calendar today, if you will please step forward and sign this, what we call the sign-up sheet, and provide the bill that you're looking to speak to. We'll be glad to. Oops, sorry, couldn't get it too far. There you go. There you go. Very well. Well, thank all of you for being here. We're going to have 4 bills for consideration. The first bill we have will be House Bill 654. The sponsor is Mary Margaret Oliver. Representative Oliver, if you will please, you want to remain in your seat here and present your bill. We'd love to hear about it. And pull the mic around. You got one? Okay. I think that's the right one.
Thank you, Mr. Chairman. I would like to speak from here, if I may. House Bill 654 comes to us from the State Bar of Georgia, specifically the family law section, and comes, as some of our bills do, really a number of our bills do, from a very bad set of facts, that tragedy came on one family in Clark County that turned into a Georgia Supreme Court analysis that told us where a gap in the law is in relation to testamentary guardianship. The facts of the Clark County case relate to a murder-suicide, a father murdering at the Athens Theater, where, as some of you may remember, there was more than one murder, and after the murder of his wife at the Athens Theater, the father committed suicide. The litigation that came after that, those tragic facts, revealed or clarified that the law today is that if you, as a testator of a will, name a testamentary guardian for your minor children, that the probate court has no discretion, that the probate court must probate the will and name the testamentary guardian, grant letters to the testamentary guardian as a ministerial act. There is no discretion. And in fact, that the probate court determination letters of guardianship granted to a testamentary guardian prevail, even order over a superior court custody dispute that would be more traditional in terms of a family dispute over where a child should go in the event that the child does not have living parents. This bill has had the benefit of a great deal of work, not only from the family law section of the State Bar and the fiduciary law section, but also 2 very good subcommittee hearings chaired by Representative Fleming, who helped us a great deal. And the probate judges, particularly Judge Jordan from Forsyth County and Judge Tate from Clark County, have assisted us in narrowing the discretion that we do give to probate court judges in those rare cases where a testamentary guardian is named and the family member, immediate family member that's specified in the bill, raises an objection. Probate judges now, with their technical changes and with the technical changes that have come to us from other lawyers that practice in this area, I think the substitute we bring to you, 295865S, is a very good set of compromises. Representative Regina Quick was not only an author of this bill with me, she also was involved in the case from Clark County and is been a member of the family law section of the State Bar that has been involved in drafting this language. Specifically, the bill provides that a probate judge shall grant letters of guardianship to the testamentary guardian unless an objection is filed. We were working on timeliness, so that if a timely objection is filed, letters shall be issued only after a hearing held pursuant to paragraph 4. There are a limited number of relatives of the minor children that are to be notified under the probate court rules, and if an objection is filed, a hearing must be held within 30 days, and the proceeding, the probate judges will be given the direction of the rules of the procedures of a guardianship act. Section 2 relates to the reality that probate judges' courts, the pleadings are by forms, and in the petition to probate a will in solemn form, there is a form set forth, put forward by the probate council and then approved by the Supreme Court, and Section 2 gives us a direct reference to the required change in the form that will come, and that is why we have delayed implementation until January 1st, 2015. The bulk of the discussion that was carried on in the subcommittee related to what should the standard be for the probate judge upon receiving an objection from a family member. Originally, the family law section came forward with a standard of best interest of the child, and we worked on a variety of different ways to tighten that. But the view of the subcommittee was that the standard should be a finding of fitness, and with clear and convincing evidence that the chosen testamentary guardian is not a individual fit to serve. If you look at line 33, 32, and 33, unless the objecting party establishes by clear and convincing evidence that the nominating testamentary guardian is unfit to serve as testamentary guardian. It was the wishes of the subcommittee that I bring for your consideration here that the discretion of the probate judge be very narrow and the rights of the parent now deceased be given preference and presumption to move forward.
Thank you, Ms. Oliver. Any questions of the presenter by members of the committee? I think we have, is it Mr. Lindsay?
Yes, sir. Thank you, Mr. Chairman. I guess my one question is in regards to the clear and convincing standard. That's also the same standard that's used for termination of parental rights. I mean, is this at the same level as termination of parental rights?
I don't think so, and I'm going to give you an answer that's not absolutely a bright line. We have an unfitness standard under legitimation statute. We have an unfitness under termination of parental rights. We have an unfitness standard under in abandonment kind of cases. The probate judges prior to 2005 did have some discretion, and there was some standards there. I don't believe that I can assert to you that it's which standard it is in relation to any of those other procedures.
Okay. I'm just I do believe that the presumption ought to rest with the wishes of the family. I'm just wondering whether or not we're imposing a standard that's different for like sort of situations in other courts. That's my only question.
I don't believe we are, because I think the case law is somewhat varied.
Right.
Anything further? No. Mr. Powell, that's yours. Thank you. Recognize Mr. Powell.
On line 29 and 30. It may be clear, but I don't quite understand 30 days of the time frame. Is that 30 days from the date the objection is filed, or 30 days from the time that the objection could have been filed? So if it's filed on the 5th day, you got 25 more days. If it's filed on the 10th day, you got 20. I'm not sure I understand what the time frame for receiving objections is.
I interpret that as 30 days from filing, but I think you're raising a very good question.
I mean, I don't remember us discussing it in subcommittee, but it just sort of jumped out at me right now.
I don't either remember that. And I know we had several different. May I ask Jill when that language entered our substitutes?
Roger, get a chair for you. We need to pull a chair out of this chair.
But in that
We'll get you nephew's chair. We got more people here, we got chairs. He's gonna have
so
to,
it's clear 30 days from the last date that an objection could have been filed, something like that. I just don't think it's clear enough in there that we not opening the door for litigation that we could avoid at this point.
excuse me. Got to get through there.
Would, within 30 days of filing of the 30 days of, filing
Of a
the
response, filing of objection.
If there were several objections from the date of the last objection.
within 30 days of the filing of the last objection, is that what you're thinking? Or what if there's no objection?
Let's talk about when we get to the point of having potential amendments offered on it, may we? Anything further, Mr. Powell? Back to, who is this? Oh, Ms. Evans? Nope, excuse me. Any other members? Let me ask, if I might, Ms. Oliver, the standard prior to the change of the law in 2005, and that was when we redid the entire guardianship code, correct?
Probate part of it.
Probate part? Okay, and what was the standard at that time?
Judge Tate is not with us today, and I know that Miss Regina,
Quick, Miss
Representative
Quick.
Quick and I have discussed
Yeah.
that. May I
Please.
call upon her about
Why don't you
that?
come forward? If you know Ms. Quick, you want to take a seat up here and let you tell us what you have as far as knowledge of that standard.
And Mr. Chairman, I'll try not to call you Judge like I did Chairman Fleming.
Don't
Vice Chairman
floor me.
I do wish that Judge Tate were here to
Yeah.
tell us definitively, because there was case law that evolved prior to 2005, and I'm going to confess that I'm not sure if that it was a fitness standard at that point.
It seems
terms
to
of
me
fitness
we've
to
always
serve.
had the position, or at least my opinion was, that as long as you had a guardian name, there was really nothing the court could do short of some showing the child was being abused, almost as a way of taking away that guardianship responsibility or right. that right?
And again, I'm not sure about how the probate court case law evolved prior to 2005. In 2005, the change was made so that it's a ministerial function by the probate court, and
Yes,
there is no discretion.
Mhm.
But prior to that, I'm not confident to say whether it was a best interest standard
Mhm.
or a fitness standard.
Mhm.
But I don't believe it was a clear and convincing evidence standard that the probate judges were applying.
Thank you.
But past that,
And I have some concern about that height of standard, because what you're looking at there is beyond, as we say, the preponderance of evidence, and is more inclined toward being absolute book proof, we'll say, of there being an inability of someone to have that right to be guardian.
yes, sir. And from a family, I'll just speak with a family law hat for just a moment. I do serve as secretary of the family law section, and from a family law section, it's a doubly heightened standard, because when you're talking about fit to serve as testamentary guardian, that is a heightened standard from a best interest, and then to heighten the evidentiary standard is certainly something the committee can discuss.
As already mentioned in the subcommittee, there was a good bit of discussion. What were the principal thoughts with resting on clear and convincing evidence as a standard?
The family law section brought forward a standard of best interest of the child, and the discussion in the subcommittee was that was not a high enough standard, that we should give more deference to the parent. So the second substitute was best interest of the child by clear and convincing evidence. And I will say that there was at least one member of the subcommittee who moved us more to an unfitness standard with clear and convincing evidence. I think that it was a very balanced debate. It was a very detailed debate. But I thought the policy consideration that the majority of the subcommittee wanted was a very narrow standard that the probate judge would have to overcome the presumption, have to undergo evidence of unfitness, have to set forth and find evidence of unfitness, and do so by clear and convincing evidence. I think the legitimation objection is clear and convincing, as is termination of parental rights. And I'll be pragmatic with you in participating in this discussion. Most of our probate judges are not lawyers. They don't have a lot of experience dealing with what we see as contested custody matters, but we are not, as a policy, I assert, going to take contested custody matters away from probate judges. I think we are going to leave them there, whether it's a normal guardianship or a testamentary guardian. So we're dealing with the procedure that does exist out there, with a policy decision from the subcommittee that the standard would be very high to overcome a parent's wishes.
Well, thank you, ma'am. Let me go back to page 1 and the sending of notice we have under the provision. I think this is the, let's see. Yeah, paragraph 2, we have sending out notice to be served by certified mail, statutory overnight delivery, return receipt requested. Who is the one responsible for making that mailing?
Under the probate court now, petition to probate a will, it is the probate judge that sends that mailing, and the petitioner is required to give to the probate court the correct addresses. And this was written in a way that not all relatives would be notified. We began with just this group, and it comes from the third party. This group of relatives mostly comes from the third party custody dispute that we had in 1921.
Okay.
I might not have it cited.
Do you feel that you have sufficient clarity to give direction who is going to be making this mailing in the law?
Yes, sir. I believe the probate judges understand that it is their requirement to do that. And that was one of the reasons that the probate judges were helpful here in both our subcommittee meetings.
Understood. Anyone else wish to address the committee on House Bill 654? Thank you, Ms. Quick. If there's no one else, we will close off the public comments, and House Bill 654 is now in the breast of the committee. Do we have a motion? Motion do pass and seconded. Do we have any amendments proposed to the bill? We have an amendment, Mr. Lindsay.
Thank you, Mr. Chairman. I think when dealing with who's going to be taking care of a child, I believe that the best interest of the child would be a superior standard, and oftentimes wills are written several years before they're utilized, and sometimes a fresh look at whether or not a particular choice is the best choice would be a good idea. And for that reason, Mr. Chairman, on lines 32 through 33, if I can do this all at once. First, I would strike on lines 32, clear and convincing, and replace it with preponderance of the. And then on lines 33 and 34, strike beginning at unfit and the rest of that sentence, and replace it placed with not in the best interest of the child. That would be my amendment.
All right, to state your amendment, as I understand it, will be the proposed amendment beginning at line 32 to at the end, striking clear and convincing, and put preponderance of the.
Yes, sir.
So it reads, the court shall award letters of guardianship to the nominated testamentary guardian unless the objecting party establishes by a preponderance of the evidence that the nominated testamentary guardian is, and then you'll have also striking, unfit to serve as testamentary guardian, and insert the nominated testamentary guardian is not in the best interest of the child, period. That's correct?
Yes, sir.
Everyone understand the amendment?
I would analogize this briefly. I would analogize this to a custody situation in terms of trying to determine who would be best to have custody of a particular child while giving preference to the parent's desire. I think that the same standard that we use in custody proceedings would be the best standard to use in this situation.
Thank you. Any further discussion on the amendment? Do we have a second to the amendment? All right. Motion to amend has been seconded. Any further discussion on that amendment? Yes, ma'am, Ms. Travis.
Right, that was my concern.
Mm-hmm.
Okay.
You could change that by why
Is
the
not,
but not a proper person
Yeah.
to serve.
is not a proper person to serve,
right.
if I may add that.
We'll do that second, that other amendment. Go ahead and prepare that one for presenting. We will first deal with Lindsay amendment. Any further discussion? Call for a vote. All in favor? Sorry. I didn't know you were talking to me. I thought you wanted to make another amendment.
Well, I was, but now.
All right. Discussion. Discussion.
In the subcommittee, we specifically addressed this, and there was quite a bit of testimony that unlike best interest of the child, which is the standard when you're talking about custody fights between parents in a domestic case, that when you're talking about a testamentary guardianship, that the general rule is you do not want to disturb what the parents have suggested. We even had a probate judge who was testifying on behalf of the bill, who said, if any of y'all mess around with my will, I will come back and haunt you. And I had a probate judge from my part of the state that sent me an email, and he said in his email that to let somebody else substitute their opinion as to what is best for my child over my opinion, because I've got some specific things as the way I want my child raised, the kind of environment I want them raised in, the kind of religion I want them raised in, and for somebody else to come and substitute their judgment as to what's best for my child over what my judgment is that I think is totally improper, and I do not think it's the proper thing for the probate court. The other thing that the subcommittee heard was that there are very, very infrequently but horrible situations where the probate court ought to overturn what the parents have decided, whether because of passage of time or whether, something's happened subsequent that the parent would not know about. And so what we discussed, and we had a very healthy discussion about it, was that we ought to give the probate court the authority to overturn what the parent had put in their will, but only when that person was unfit, or that needed to be by stronger than preponderance of the evidence. Now that, certainly it's in the breast of the full committee, but I wanted to let you know what our thought processes were as far as putting a very high standard, both as to the evidentiary part of it and as to the standard as to whether we're dealing with best interest or unfitness of the nominated person. So
Nice.
So bottom line,
Nice, compelling argument.
I am against the amendment.
Thank you. We have Ms. Evans. You got your button? Go ahead.
Thank you, Mr. Chairman. May I just ask a question to Representative Oliver?
Sure.
And this is just, I don't practice family law, and now I'm getting really scared because I also don't have a will that says what's going to happen to my child, but what is
You make us
what
children.
I need to work on that. What is the reason that the will itself is not enough standing alone to get these letters? Is there something that parents are supposed to do in addition to having their will set out, their preference set out in a will?
There's no parent left.
Right.
Here's the reality. We have a deceased parent and a third-party relative. For the third-party relative to have authority to put the child in school, give medical care, the third-party relative or a stranger named as a testamentary guardian must have letters of authority that are granted by order of the probate court. Does that help you?
Well, my question is more, it sounds like what we're dealing with here is a situation where there wasn't something that was supposed to be done, but there was a statement in the will about where the parents wanted the child to go. Am I right about
Yes.
that?
Yes.
So what is it about the fact that the statement in the will is not enough to make that transfer happen?
Under current law, the statement in the will is totally determinative as a ministerial act, and the current law, the probate judge has no discretion to notify anybody or to do anything other than issue letters of guardianship. That's
Okay.
the current law.
And so we're stepping in
We're
and
considering that a gap in the law, and
Okay.
I think the subcommittee was convinced, all of us, that there was a gap in the law here, and then we had a vigorous debate about procedures of who to notify and the standard of review, the standard that the probate judge should follow.
thank you.
All right, back to Mr. Lindsay.
If I may sort of explain my position a little bit more, and I do wish for the deceased parents to have deference shown to their choice, but I am concerned that oftentimes these choices are made years before the will is actually activated. I'm also concerned with the fact that an unfitness standard, that's reminiscent to a standard set for termination of parental rights. That's very similar to that, particularly with the clear and convincing evidence. I don't believe that, particularly when you talk about that a child has been traumatized by the death of their parents, that in order to determine who would be the best person to have take care of that child, that the same standard for overruling the parents should be the same standard that's being used for terminating parental rights. I just don't think that's realistic. I think that while the parents should have preference, and I certainly wanted when it was applicable in my will for my preferences to be taken into account. But with the parents gone, with the child still alive, I think that the court should rightly, and the various interested parties should rightly look at the best interest of the child in order to determine where would be the best place for that child to live. That's the reason for my motion.
Thank you. Any further discussion on Lindsay amendment? If not, the chair will call for the question. All in favor of the Lindsay amendment signify by saying aye.
Aye.
Those opposed, same sign. Chair is in doubt. Chair will call for show of hands. All those in favor of the Lindsay amendment, please raise your right hand. All those opposed to the Lindsay amendment, please raise your right hand. All right. The Lindsay amendment fails, and we'll move to the next amendment. Are there any further amendments, Mr. Powell?
I don't know if this is the best way to do it, Mr. Chairman, but I will offer this, and then the committee can help me through it. On line 30, after the word days to the end of that sentence, I would delete that and add of the date of the filing of the last objection file.
Second.
Hold on a minute. The date of the filing of the last objection.
File.
All right, so what we have, the chair will read out what he understands the motion is. We're striking out on line 30 the remainder of that sentence, which ends with objections, period, and leaving days. Yeah, I'm sorry, leaving days in. Excuse me. So 30 days. Days is left in. Strikeout of the time frame for receiving objections. Period. As being struck through and inserting. Be reading within 30 days of the date of filing of the last objection filed. Is that correct? I don't think the language is suitable to our legislative council. Ms. Travis?
It is. Of the date of the filing of the last objection filed is what I said. That doesn't necessarily mean that's what it ought to read.
I don't know if we need to have objection filed, just be the last objection, period. Would it not? The filing of an objection, that'd be the last one, whatever it is. So it'd be 30 days of the date of the filing of the last objection, period. Will you accept that as being your amendment?
Yep.
Any discussion on the amendment? We have discussion by Mr. Jacobs.
Well, there is a time period for filing the objections, right?
There is, but what it says is 10 days from the date you were served. So if you've got 5 people who were served at different dates, then you could have time frames for people filing objections that are different. And so you could have a timely filed objection on the 15th of the month, the 16th of the month, and the 17th of the month. So it needs to be 30 days from the date of the filing of the last objection, is my thing.
Okay.
Anything further, Mr. Jacobs?
He's still thinking.
His eyes rolled back.
That'll.
Well, keep thinking about it. All right. Do we have any further discussion on the Powell Amendment? Everybody understands the Powell Amendment. The chair will call for a vote on the question. All in favor of the Powell Amendment signify by saying aye.
Aye.
Opposed, like sign. Amendment carries. Do we have any further amendments? That's not an amendment in yours, is it? I think I it's laid your phone on. No further amendments. The chair will call for the question, which is the due pass of House Bill 654 as a amended and committee substitute. All in favor signify by saying aye. Opposed, like sign. Motion carries. Thank you. We next have is House Bill 758, and Representative Comer, are you present, or someone here on House Bill 658? 758, excuse me, 758. No one here. Whose subcommittee did that come through? I don't think it did come through. That's right. It's a simple bill. That's what I did. I said, well, it'll be a simple bill. We'll just do it without a subcommittee hearing. What they're doing is, as often occurs, a judicial circuit is seeking to change the term of their courts in that particular circuit, and this is pertaining to Bartow County, to be first Monday in February, May, August, and November, where it currently is first Monday in February and August, fourth Monday in April, and third Monday in October. So they're putting on this a date, the first Monday in February, May, August, and November. That's the only change. Any no amendments? All in favor of the motion do pass signify by saying aye. Opposed, like sign. Motion carries. Next we have is House Bill 794. Representative Braddock, you come forward. I'll ask you to take the seat and present your bill to us, please. Which one you want on? That one, all right?
Yeah.
That's fine.
Thank you, Mr. Chair. I want to call up Harold DeMoss. He's with the Compact for a Balanced Budget. Compact for America, sorry. And Andy Welch is coming up. He's also a co-sponsor of this bill. And what this does is this is a compact among the states to call for an Article 5 convention and to get the federal government to balance the budget. It limits their ability to raise the debt ceiling, and it's an innovative approach to having an Article 5 convention without the fear of having a runaway convention. There's a lot of safeguards built in to prevent that. And in the bill, the rules of the convention are known in advance. The delegates of the convention are known in advance. The voting procedures are known in advance. The single constitutional amendment that's being proposed is deliberated at the state level, and the language is defined, so that's known in advance before you ever go. And it's an up or down vote at the convention, and it's just a tightly crafted way to finally get Washington to do something and be fiscally responsible. So I'm going to let Andy go through.
Sure. What would be the
I want you to present the bill by going through and giving us some oversight as to specific statutory sections you have here that would apply and how they are to be addressed as far as the purpose of the bill.
Yes, Mr. Chairman. Okay. Ladies and gentlemen of the committee, the compact initially deals with, and I'll direct your attention with the definitions section. This is under Article 2 of the compact. Article 2 deals with definitions, and on page, I'll direct your attention to page 3. This is the core language of the amendment that that's being proposed. This would have this would be the language that would be installed into the Constitution if ratified by 38 states. Section 1, beginning on line 54, deals with the requirement that there be a balanced budget by the Congress. Section 2 sets a debt ceiling. The debt ceiling would be that in which exists at the time of ratification. So if it's $20 trillion is the debt at the time of ratification, then 105% of $20 trillion, which is $21 trillion, would be your debt limit. So it automatically sets the debt limit at that amount. At the current burn rate of Congress and interest, that's about a 2-year window with deficit spending. So it gives Congress anywhere from a year to 2 years to
Keep the door shut over there. Keep the door shut, please. Keep the door shut. Thank you. Too much noise in the hall.
Thank you, Mr. Chairman. And that's two years to allow for the Congress to adjust spending. Section 3 is the release valve. This is where the states have the authority by petition of Congress to increase the debt limit. It requires the vote of a majority of states. And in this sense, you're having a board of directors overseeing what the debtor is doing. Currently, there is no creditor that oversees the debt that is spent by the debtor. This would actually provide a board of directors in the sense of the states overseeing that debt. Section 4 deals with an impoundment provision, which, if the debt reaches the point of 98% of the debt limit, the president is required to impound monies. In other words, choose which bills she's going to pay, and then to hold that back until Congress makes a decision as to where it's going to save money so that the bills can be paid and decide which bills will be paid. So Congress can actually override the president's choice of impoundment. Section 5 deals with taxation, and in this section, a simple majority vote can be used to do away with exemptions and loopholes in the tax code in order to make sure that there's enough revenue to pay the debt and to balance the budget. It would require that a supermajority of 2/3 of vote of the Congress would be required in order to raise taxes on your standard tax base of income taxes, for example. And then also, if the Congress does want to substitute an income tax for a consumption-based tax, then it may do so by just a simple majority.
Can we stop for a moment on that point, just
Yes,
to
sir.
where we are with this? This is the proposed language which would address the constitutional amendment if approved by the 37 states.
38.
38, sorry. If we have, during the convention, a discussion, debate, and it becomes a position of the majority that some portion of this language needs to be modified, is there a ability for that to occur, or they're committed strictly to whatever that language is, and nothing can be changed?
You're correct. It's the latter of the two. Once the language is approved by the 38 states in the compact, then that's the language that you vote on. It's up or down vote. There's no drafting or changes made at the convention.
So even within the 38 states, so it says, I just don't like that wording, we're going to modify the wording, that would not then constitute a member of the compact, even if they pass the legislation.
That would be a breach of the compact, yes.
All right.
Now, but what is important about this is that when you start the compact process, once those states form the compact, which you need 2 to start, once that's done, then you have the opportunity through any subsequent states to go back and amend these compacts if, as we progress along, better language becomes appealing and the states say, we want to change that. But as it is right now, you have to start with some point in time as to what you think the language would be.
I'm going to have to ask the door to stay shut during debate. If I need to, we'll get an officer from the Capitol to come over here and stand by the door, but I don't want any more opening and closing of the door while we're going through debate. It's too distracting and hard to hear for the people on the committee. Go ahead.
Thank you, Mr. Chairman. So there would be the opportunity for adjustments, but it would be through the compact itself. So once you have states joining the compact, discussions can be had at the commission level to decide, well, we want to change this language, we'd like to see this, and if the states that are members of the compact agree, then that would be changed.
Well, how will those states make that change?
They would have to do it through the legislative process.
Correct.
Back home.
In their states.
It would not be through the commission, no.
Correct. Okay.
And then Section 6 deals with your definition sections, describing the specific terms that are outlined in the proposed amendment for a balanced budget amendment.
All right.
Section 7 is just a self-enforcing provision of the article. That covers the language of the constitutional amendment, and I'm happy to take questions, and Chip DeMoss is here. We're happy to take questions at this point if you'd like, Mr. Chairman, or we can proceed.
Go ahead.
Okay.
Proceed.
Article 3 of the compact discusses the compact membership and withdrawal, allows for the states to join after they pass the compact through their legislative process, and then it would also allow individual states to withdraw, and you can withdraw at any time for any reason prior to the 38th state joining the compact. Again, home rule is controlling, so the state's law still controls. You're not waiving any of your state law with respect to the compact. There is a requirement that we have. Just looking down here to make sure I'm checking my. In Section 3, under Article 3, which is on page 5, in working with the Goldwater Institute and the Compact for America, we were taking this language and trying to revise it in a manner that we thought was appropriate for the state of Georgia. And in Section 3, we made exceptions so that various compact members could deviate in their compact slightly with respect to how they chose their delegates to the commission or to the convention. Some states may want to just send their governor, which was the case at the Constitutional Convention. Benjamin Franklin, I think, was governor of Pennsylvania, and another governor was sent as well, and that was the sole representation from those states during that process. So it varied from time to time, but you could have a governor go instead of legislative individuals, or you could have legislators go, or a mixture of the both. So we did not want to preclude any state from deciding whether they wanted governors, legislators, or both to go. So this allows for some changes or differentiation between the compacts. Article 4 deals with the Compact Commission, and this forms a commission. Once 2 states are formed, then a commission is formed, is created by 3 volunteer individuals. Those individuals, and the purpose of the commission is to work on getting more states to join the compacts. So you then have a tip of the spear, if you will, that can go to work with more states. Currently, I think 6 states are considering a compact proposal: Alabama, Alaska, Arkansas,
Arizona.
Arizona, Texas? No, I don't think Texas.
They didn't approach Texas.
Several others, and so we would like to, of course, be, in the lead on that. And what's interesting, once the commission is formed, the first state to actually adopt the compact becomes that state's delegates to the convention actually serves as the chair to the convention, and so would moderate and control the convention. Also, you're going to be able to set forth the first individuals to the commission. So those first states that join actually have some control, regulatory control, if you will, over the convention and the commission itself. Funding is by the individual states that join. Section 7 on page 7 just goes through the key events of notice. Article 5 is where requires the resolution for applying for the convention, and essentially this compact serves as the congressional application for a balanced budget for convention, and that language is set forth in section 5. Article 6 deals with the delegate appointment, and this is important. I'm sorry? We'll let you come back in that. Article 6 deals with the delegate appointment limitations and instructions. This is where the compact confines the delegates to a simple up or down vote at the Constitutional Convention, and their authority is limited by the compact, so they're not authorized to deviate from that charge. This gets into it also gets into who is selected as delegates. In this version of the compact we've presented to you, the delegates that serve at the convention would consist of the governor, the Speaker of the House, and the President pro tem of the Senate, or their designees. And the vote of the three of them, the majority vote of the three of them, constitutes the vote of the state. In Article 7, the convention rules are set forth that specifically are there to address just the vote on the balanced budget amendment, the language contained in the compact. And also there's a requirement that the convention be fully transparent. We wanted to make sure that the public could watch and witness the convention and observe that, so as to ensure that there was a sense of keeping with the commitments that the compact states have agreed to. Article 8 is a prohibition on ultra-virus conventions, and that essentially says that if you act contrary to the compact, the convention is null and void, the actions are null and void, and the member states have the authority to enforce those provisions. Article 9 is a resolution ratifying the balanced budget amendment. This would be automatic upon the adoption by 38 states of the balanced budget amendment. Then the balanced budget amendment takes effect, and it would be automatically ratified since all 30 states, since the requisite number of 3/4 of the states have approved it, which is 38. Article 10 just deals with your construction enforcement and some of your boilerplate language. The venues in this was chosen to be the Northern District of Texas in terms of litigation. That can be changed by the commission. And then also there is it's also preset as to the location of the convention. That can be changed, of course, by the parties. But right now it's set for Dallas, Texas, at 9 a.m. The point of this, I know this is a detailed document. It's a long document, but the point of the document is to specifically spell out to the state and to the public and to you, the members of this committee, and to the members of the House of Representatives, exactly what would happen if the compact was formed and if the convention was held. So you would know ahead of time, and you would not have a drafting convention so that parties could sit around and draft the constitutional amendment, and the language may change, the purpose and intent of the parties may change, so that you have what is commonly referred to as a runaway convention. And that, in short, sums up the compact, Mr. Chairman, and I'm happy to try to answer questions about it. Chip DeMoss is here, and he also has information that may be helpful to the committee.
Yes, sir. You want to address the committee?
Thank you, Mr.
Before we
Chairman.
start questions?
I know Nick Dronius was here at the last session,
Yes.
and he may have passed out some written testimony to present to you. The reason I'm asking is my father is Judge Harold DeMoss of the U.S. Fifth Circuit Court of Appeals. He's a senior judge, and the inspiration behind the compact really comes from Judge DeMoss. He sends his warmest regards to you and the committee members today, and he asked if at all possible, if his written testimony, his position paper on why the Compact for America is right for this moment in American history, if you'd be so kind as to allow that to be introduced into the record.
Certainly. Please do. Yeah, that will.
There's other written
whole-
testimony in there from the members of the Compact for America Advisory Council, including 2 leading economists. Also, Ilya Shapiro at the Cato Institute is on the advisory council. That's all relevant information that we would like for the committee members to receive. Really, the Compact for America has 4 pillars. 1, to impose fiscal responsibility onto Congress. 2, to begin to restore the relevancy of the state legislatures when it comes to federal policy. Provide a way that state-initiated constitutional change can occur quickly, efficiently, and safely.
Keep the door shut. We got too many in the room as it is. We're overcrowded. This room can only, by capacity, I think, hold 50 people. And I think we're beyond that as it stands now. I'm going to have to ask, if you will, Michael, go get a guard and put up the door and not let anybody further come in until the place empties out somewhat.
Yes, sir.
I'm sorry. Go ahead, Mr. DeMoss.
Thank you, Mr. Chairman. Again, to provide a quick, safe, and efficient way for the states to initiate constitutional change to deploy the powers granted to them under Article 5, but in doing so, embracing the concerns of Eagle Forum and other groups that have been expressed for years. We spent 2.5 years developing this compact vehicle by doing just that. We engaged Andy Schlafly with the Eagle Forum for a period of
Sorry, go ahead.
4 months. Mr. Schlafly knows Judge DeMoss. Judge DeMoss was on the conference calls with Mr. Schlafly as we were discussing the compact with him, and they were very instrumental in making this compact what it is. Just consider the compact. It's simply the delivery vehicle. It's carrying a payload. The payload is the balanced budget amendment. You don't even get to the compact unless you decide, first of all, that you like the payload and you want to both propose and ratify that payload. If you can get past that point, then the compact itself is just the delivery vehicle to do that quickly, safely, and efficiently. So if you put it in those simple terms, it may make this 12, 15-page document a little bit easier to understand. And I'm here to serve at the pleasure of the sponsors and you, Mr. Chairman.
Thank you for being here. You came from
Houston, sir.
Houston. All right. Thank you for your appearance today. Let me start out with my initial question, which I think I also asked at the time in subcommittee, but I'm still concerned about it. I'm not a constitutional scholar by any means, but the concern I have with regards to the binding of future legislative bodies, which is what we're seeking to do, and I say under the Georgia Constitution anyway, there are limitations as to what we're able to do as one legislative body saying you can't change the law, this will be law for a future body, and I realize it doesn't become irrevocable until you have the 38 states agreeing to it, but all of a sudden you have 38 states and Georgia's legislature says at that point in time we don't want to participate, and yet you're saying this is irrevocable. And so I'm torn between that part of it as far as how do you enforce something against a legislative body who has the ultimate say-so about what they're doing or not doing under state law. Anybody want to answer that?
Can I just qualify? I'm not an attorney. I'm a CPA,
Okay.
so don't.
Don't stare at you. Okay.
I think
I think it is a very valid concern. I think that the principle behind this is state sovereignty. I mean, what we're talking about here is states exercising their Article 5 rights. As a state, each state has the same right as any other state in the Union to petition its federal government for a convention.
Yes.
And it is a question of the manner in which you get there. This compact is designed to try to keep a unified front going forward. It does that up until 38 states. Anyone can withdraw. If and after the 38 are there, even at that point in time, the Commission can allow a member state to withdraw at that point in time. So there still is a slight release valve. But nonetheless, what you're saying is correct, Mr. Chairman. You are conveying, in a sense, for that moment in time, you are conveying a commitment to stick with the process. I think that it's a very narrow conveyance of state sovereignty for one particular reason, and that is for the Convention for a Balanced Budget. And one thing to, I think, keep in mind, the committee should keep in mind, is that the actions that our federal government is taking in the continuation of extending debt is an action that is committing future generations without their vote to have to pay off that debt and share that burden, and no one is speaking for them. So I would hope that we would take the position that we would want to move forward with that convention. We want to move forward with that endeavor.
I think, speaking for myself, I know other legislators, we all have a burning desire to do something to put a bridle on what's being done at the federal level. I know there's several bills floating around, or resolutions with bills, or bills with resolutions rather, that are seeking to do things stepwise, starting the process. And I guess the question we have to address starting here in this committee is, what is the appropriate process to be considered as a way of accomplishing that? And I want to say it in the sense that as you take the photograph of the moment, we're doing it today without knowledge of what may be 2 or 3 years from now, the circumstances when they come to the convention, but we've already detailed the language that cannot be in any way modified by the members of that convention. And even as you say, back during the initial Constitutional Convention, there were states seeking to withdraw, but they were persuaded not to. They could have, certainly at that time. And we're trying to now limit the ability to have a withdrawal. Those are some issues. Ms. Bragg, you want to add something?
Yeah, and the way they've layered, certain things to be activated after certain things happen throughout this document. The window in which we're bound is once 38 states join until the time that they go to the convention, which we estimated to be about 60 days, because anyone can withdraw from the compact prior to that. So it's a very small window.
So after that 38, the thing I'm looking at is taking the photograph today of what we're going to do at that convention, and not being able to say to those who are at the convention, we've got to do something a little more wordy-wise, changing something here, that they won't have that ability as part of the process. That's a concern to me. That's all I'm saying. Many of us, I'll say all of us, many of us look to see how can we put some type of bridle on the spending by the federal government. I think we got a question over here. Here is Mr. Roger Bruce.
This something similar to this came up in a committee meeting yesterday, and I'm going to ask the same question that I asked then. It appears that you're trying to do two things at the same time, and I'm trying to make sure I understand what is really at the basis of what the bill is. It looks like you're trying to get the federal government to balance its budget, but it also looks like you're trying to establish a methodology for conventions ad infinitum. And so I want to be clear what the purpose is, what your purpose is, because what it appears, and I'm just trying to make sure I understand, what it appears is that that you're using a topic that people have an emotional tie to, which is balancing the budget, in order to get control over how conventions are put in place and trying to move things forward by appealing to people's fear about the budget. But it's two different things. So what's going on?
Mr. Chairman, may I?
Sure, respond.
Representative Bruce, I think that you, I would maybe disagree with some of the characterization, but I think that you're right. What we're doing is we have a balanced budget amendment in a compact, and the compact is the vehicle by which to get there. So what you're doing in this legislation is that you are establishing a mechanism by which the states in this union can come to an agreement as to language before you get to the convention, to avoid a runaway convention where any and all things of the Constitution would be up for grabs. So you're trying to define before you get there what the rules of the game are going to be and what the language is going to be. So if that is successful, and if the state and other states join in, then that could set a precedent for how future amendments are considered by this country, bearing in mind that you still have to have 3/4 of the states in this country to agree to the compact before it ever has any real effect. And the other part of it is actually to, sincerely, and I mean this in all sincerity, is to limit the increasing debt and that the federal government continues to build up against our future generations.
Okay, but if it is that the state, if the legally elected representatives of the state wanted to get a message to Washington to say that we want you to balance the budget, could we not do that by having a resolution voted on saying we want you to balance the budget? And then separately from that, if we wanted to have some sort of rules around the convention, then you would have legislation that dealt specifically with the convention, as opposed to trying to put the two things together and clouding what's really going on.
Well, there's nothing going on in the sense of trying to, there's no one trying to pull the wool over anybody's eyes here. Your proposal is exactly another way that it can be done. You can submit an application. And in fact, the state of Georgia submitted an application, I believe in 1976, for a balanced budget amendment, just a convention to talk about a balanced budget amendment. So did countless other states. But the number of those, I say countless, it wasn't enough. It was 32 states. There was not enough states to do it. And over that period of time, it's been unsuccessful in trying to build that convention. So you can do it that way theoretically, but it has not ever happened.
Okay, one last thing, if I
Yes,
could.
sir.
One last thing. How many times have we amended the United States Constitution?
By Article 5,
How many? We've added 26,
we got
26 amendments to the Constitution. Is
but-
that correct?
But not through a state.
But we've changed it 26 times. So there is a methodology in place already to change the Constitution of the United States, and it's been done 26 times.
Correct.
So it works. The country's not that old. So 26 times it's been done. Is that correct?
Yes, sir.
So there is a process in place that allows us to do it if the country wants it done. Is that not correct?
Well, can I speak now, Mr. Chairman? Well, the country obviously does want it done because this polls bipartisan, north of 75% across the nation. And the last time something was ratified to the Constitution, it took 215 years to get it done. So the approach to take an Article 5, every amendment that's been ratified to the Constitution, it was a supermajority of Congress, and they're obviously not going to act to tie their own hands. So it's going to have to come from the states if we're serious about fiscal reform in this country and saving this country from financial ruin. And we're almost at the tipping point of no return, and I'm very concerned. But this approach is one of many we could take, and if we don't act, then I'm not sure we're going to continue to operate. But it's oh shoot, I had a thought that escaped me.
Right.
Anyway, but I don't think Congress is going to act on their own, and the only time they've had amendments is with the supermajority of Congress. So
Thank you. Yes, sir, Mr. DeMoss.
Thank you, Mr. Chair. And just one brief comment to that. You're exactly right. All previous amendment efforts had been through the congressional initiated part of Article 5, but not one of those amendments has ever limited the power of Congress. They've never proposed an amendment to limit their own power. So that's the big difference here. Is it's the states proposing an amendment that would actually limit the power of Congress. Thank you, Mr. Chairman.
Thank you. Any other questions from members of the committee to the presenters? I guess in closing, let me say that as I read the need as you have it for the compact is because of the fear or concerns. If you just have the regular call of a convention, it may be a, quote, runaway convention, and no one can limit what can be brought forward or done by that convention, even by taking pledges, whatever it may be. You're seeing that use of the compact as a contractual way of limiting that approach.
Yes.
Is that correct statement?
That's correct.
Thank you. We have several people who would like to address the committee, and one is, I'm going to try to read the names here. I have David Goldenshoe. Mr. Goldenshoe? Yes, sir. Goldenshoe. Thank you. Come forward and we'll let you address the committee. Tell us who you are and who you represent, if you're in fact representing someone.
Mr. Chairman, my name is David Goldenshoe. I'm a lifelong citizen of Georgia, a lawyer up in Rome. I am someone who has spent a great deal of my time getting up to speed on the constitutionality and specifically Article 5. And that led me to join forces with the Convention of States project, which, just like Compact for America supports this group, the Convention of States project supported Senator Staten, who submitted Senate Resolution 736, calling for your kind of typical Article 5 convention for certain purposes, very similar to including imposing fiscal restraint as the Compact does, taking a few other steps, very limited, that could rein in the federal government. So I'm very familiar with this, and I am here to say to the committee that we support all of the Article 5 efforts, and we are aware that there are a number of them that you have to deal with this session. In addition to Senate Resolution 736, which passed today, 37-16 in the Senate, and will be coming over to the House, you had last session Senate Resolution 731, which is calling for a convention for a balanced budget amendment. You have Senate Bill 206 that may come before you, that is the delegate selection bill, and now you have this bill, the Compact for America. And they all have positive points, and there are those who would contend that some of them have negative points. As you pointed out, your concern about the irrevocability with the Compact for America. I, again, support the Article 5 efforts, the Compact for America. One of the things that I think as a committee you should look at is the fact that it does require a congressional resolution. In other words, Congress in advance has to more or less go along with the states doing this. And if one looks at the history of Congress, they've not traditionally done very well at passing legislation related to Article 5. I don't say that in any way to be negative about the Compact. I simply bring it to your attention as one of the things that you need to look at. As I say, I support Article 5. Ultimately, at some point, I may very well be back before this committee promoting Senate Resolution 736. And I hope that my friends from the Compact for America will be here to support me then, as I am here to support them today. I would close by simply saying the polling is well over 70%. The citizens of this country across the board are tired of an overreaching federal government that is spending us into bankruptcy, and it is both administrations, Republican and Democratic administrations, that have gotten us to this point. It is a nonpartisan and certainly bipartisan issue. And sometimes when I talk about it, and I will say I have talked about Article 5 to literally, over the last 6 months, thousands of Georgians. We have a website that just is educating people on Article 5 that has had over 60,000 hits on educate and sign-ups just in a few months. People out there, the citizens, are worried about this, and they want to see you do things. And when I look at our federal government, I kind of picture those of us on the in the Article 5 battle. I picture us as kind of like the cavalry coming up over the hill, and there's all of us out there, and we need a full frontal charge on the federal government to rein them in. And you've got the compact folks in that regiment, and you've got my group and one and others. And as long as we can get to the federal government without shooting each other in the charge, then hopefully we can be successful in this process. And that is why I'm here today to say that we support the Article 5 process. When Senate Resolution 736 comes across, we think it addresses a number of the concerns that you have. I know there are concerns about runaway conventions, and I have studied that to the hilt, and I cannot think, I'm a pretty smart fella sometimes on some issues, and I cannot come up with and have challenged Eagles Forum, John Birch Society, and everyone else to give me a realistic way where any Article 5 group could convene, propose amendments, propose some rogue amendment, and then that rogue amendment get adopted by 38 states. It's not possible. It simply isn't possible. We couldn't even pass the Equal Rights Amendment. We couldn't get 38 states. And that just happened to protect the rights of about 52% of the voting population. So the idea that a rogue amendment could ever happen is simply fantasy. And I challenge anyone to prove me wrong on that. So, sir, I will convene by simply saying thank you for this, and we look forward to getting here with 736 as well.
Yes, sir.
Thank you, sir.
Thank you very much. Gail Englehart. Gail Englehart. I'm sorry, Ms. Englehart. It's best because we have recordings of the meetings. I hate to require you to come around, but in order to speak, we do require that you be in a chair to have a mic. There we go. They got you in the corner there somehow. Thank you for coming. Have a seat, and please tell us if you're here representing a group, who that group is, your name.
Yes, I'm Gail Englehart. I'm from Bartow County, Cartersville, Georgia specifically, and I happen to be a district captain for the Convention of States in District 15 and 52. 52 Senate, 15 Representative. I'm here to, as David said, to support all the Article 5 activity that is going on, and that I firmly believe that we complement one another, that our ultimate goal is one, to save our nation, to save our constitutional republic. Obviously, the federal government is not going to fix itself. If they were going to, they would have done it by now. And so this is a way of the states to take control. And after all, the states founded the federal government. They formed it. And this is a way for the states to take control back and to rein in the out-of-control federal government.
Great.
Thank you.
Anyone have any questions of Ms. Englehart? Appreciate you coming and being with us today.
Thank you
very much. I believe I have Julianne Thompson. Ms. Thompson. And you've got another lovely lady with you,
Just here.
Debbie Dooley.
She's just
Here,
going to sit
support.
here with you to support.
All right. Pleased to have both of you today, Ms. Thompson, Ms. Dooley. Give us your name and if you're representing a group, what
Yes.
that group is.
My name is Julianne Thompson, and I'm here today. I'm representing myself, but I'm co-chairman of the Atlanta Tea Party, and I'm involved in a lot of different organizations in Georgia. And I want to thank you, Chairman Willard, for the opportunity to testify here today, members of the Judiciary Committee. I just want to start out by saying I was originally adamantly opposed to an Article 5 convention. I was terrified of the idea. I was convinced of a runaway convention, and it wasn't until January of 2013 when someone from Compact for America, a gentleman named Kevin Gutzman, came to speak at an event that we held in Beaufort last year, that a lot of my worries, well, the vast majority of my worries were alleviated. This year we have Michael Ferris coming from Convention of the States. We also have someone coming from CFA as well. And I want to say that you have an opportunity here. You have several pieces of legislation, and I'm here to support them all. But I just want to say that we're on a fast-moving train to financial destruction here in America that we're not going to be able to recover from. We cannot depend on Congress alone to stop it. We need a balanced budget amendment, and we need it as soon as possible. There are 3 good pieces of legislation before you this session, and I believe we must pass all 3. In 2014, Georgia has the opportunity to be a national leader on the subject of an Article 5 convention, and we cannot afford for personal politics to get in the way of that. It's not about Republican versus Democrat or right versus left. It's about our future, the future of all Georgians and all Americans. There are good people sponsoring and supporting every Article 5 bill this session, and it is not a time to draw a line in the sand. This is about our children and about giving them the hope and opportunity to grow up in a free and prosperous America. And it is for that reason, as a mother of 2 young children myself, that I ask you to vote in support of the Compact for a Balanced Budget Amendment.
Thank you, Ms. Thompson. Ms. Dooley, you have anything to add?
She spoke for me very well.
All right. Mr. Bruce?
Just curious. It used to be a time when we based the value of money, because you keep talking about balancing the budget.
Yes, sir.
It used to be based on the goal in Fort Knox. What is it based on now?
What is what based on?
The value of money.
What is it is what it is told for us to be by the Federal Reserve.
It's really not based on anything.
No, it's decided by the Federal Reserve.
And it's based on somebody's willingness to accept U.S. money, currency, right? So how did you guys come up with the amount of money that should be allowed, that the federal government should be allowed to spend? What is that based on? What is the value based on?
Debbie, would you tackle that question?
What is the value of your household budget based on? The amount of money you have actually coming in. You can't go out. You can't be allowed to call your credit card company and say, ooh, I see this car I would like to buy, so I want you to increase my credit line. The government should live within their means, just like every household in this country does.
Okay, but I can't print money in my house.
That's right.
Okay.
You're not allowed to, but the federal government is.
That's why I'm asking, what is it based on? What is the value of money? How did you come up with how much money the federal government should be allowed to spend? Since they can continue to print it.
How much are they taking in? How much money do they have coming in? They should not be allowed to spend above what they have coming in. I have only person in my household besides 2 doggies and 2 kitties, and I have to live on my means. I have to live on my income.
Okay.
So the federal government should, and the reason that the state initiated compact is good from the states, we can't depend
on Congress to want to balance the budget, because they have a lot of big business in both political parties that control the process. They don't want a balanced budget. They want to keep spending. A lot of the major, gigantic corporations want that spending to increase. So it's going to have to come from the state level to actually put a stop to it. And I have a 5-year-old grandson, and we have already mortgaged his future. And we've mortgaged your grandchildren's future and your grandchildren's future. And until we can actually have a upcry from the grassroots and from the states, we're not going to see a change, because these big lobbyists in Washington, D.C. have a whole lot more money to spend in both political parties than the average Joe Smo on the street have to spend.
Okay, so the answer is we don't know the answer. Okay.
Good answer.
Thank you.
Good answer. Mr. Welch, you have a question?
No, Mr. Chairman, I think that Ms. Dooley adequately responded.
All right. And last we have over here, yes, sir.
Thank you,
Mr. Mabra.
Do you think if we send better people up to D.C., the problem can be solved?
I think we've been trying that for a long time. Now, I don't want to discount the fact that if Representative Lindsay ends up in Congress,
we're gonna get a pledge out of him before he goes. I know that.
Sorry, that's how. I rest my case.
And I have signed this, that I'm a sponsor of this bill.
All right.
So, and to answer
Thank you.
your question, a lot of people in this room know who Jack Abramoff is, the lobbyist that actually served time in jail. And he was here for us, I believe it was last year.
it was last year.
And he made a very good statement to me, and I think is very applicable. He said that someone can go to Washington, D.C. with the best of intentions, with fire in their belly, and he said it's just a matter of time before the system has them in their grips. It's just a matter of time, and this is with both parties. This is not a Democrat issue, and it's not a Republican issue. But we believe this is a way of power belonging to the states and to the local individual and people here on the ground, everyday citizens that are in each of your districts. And I think that's why it's important, because until we reform the system in Washington, D.C. and the way things are done and in regard to lobbyists, we're not going to see a change. But from the state, the good people in Georgia can say, we're going to work to change this, and I think it can be successful.
Thank you. Thank you, ladies, for
Thank
being
you.
with us today. We have one more
Thank you, Chairman.
in the interest of time to speak, and that'd be Ms. Suella Debweiler. Come up front, Ms. Debweiler. Give us your name, and if you're representing a group, who that group is.
Yes, sir. Thank you so very much. I appreciate the time. I'm Suella Debweiler. I write a Georgia newsletter, Georgia Insight. I monitor the legislature and report on what's going on here. Also, I represent Eagle Forum and Phyllis Schlafly's group. So I would like to enter into the record the opinion that I'm going to read from, which is an opposing opinion. And this is the gentleman who wrote this. He's Dr. John A. Eidsmoe. He is in Alabama, the State Defense Force. He holds 5 degrees in law, theology, and political science, 2 doctorates, 1 in law and 1 in the ministry. He's authored 12 books, including Christianity and the Constitution. He has taught legal history and church history at law schools and seminars. He currently serves as professor of constitutional law and related subjects at the Thomas Good Jones School of Law, Faulkner University in Montgomery, Alabama. He's an adjunct professor at Birmingham Theological Seminary. He's a constitutional attorney and retired lieutenant colonel in the USAF Reserve. He's also a graduate of the Air Command and Staff College and the Air War College. And I have a copy of the statements that I'm going to make here. I'm not going to read every word he says, but I'm going to. And this is his interpretation. His interpretation of what you're considering here.
Yes,
House Bill 794. Article 1, Section 10 of the U.S. Constitution, which provides that no state shall, without the consent of Congress, enter into any agreement or compact with another state. He said the state, because this compact may encroach upon the authority of Congress to make rules for a convention, the constitutionality of this compact is open to serious question. The amendment further provides that if revenues fall considerably behind expenditures, the President must impound funds to prevent the deficit. This appears to give the President unlimited authority to determine which funds to impound and not to impound. Article 5 is utterly devoid of any provision or even any implication that the states or any compact formed by the states has any authority to make rules for a convention. If 2/3 of the states pass convention calls in the form of this bill, Congress could either treat those calls as invalid in their entirety or accept the convention calls as valid calls but ignore the conditions of those calls. Article 5 is utterly devoid of any language that suggests the states may place any condition on their calls for a convention. The bill limits each state to 3 delegates, talking about the constitutional amendment. I seriously doubt that Congress would ever call a convention in which each state had only 1 vote. If Congress calls a convention and sets rules that differ from those set forth by the states in their compact, the Supreme Court would probably have to decide which takes precedence. Based on the supremacy clause of Article 6, Section 2, the court would probably side with Congress. According to the bill, the compact would provide that if a convention acts contrary to the compact rules, the compact states agree to withdraw from the convention. But the likelihood is that the Congress and the court would invalidate this provision of the compact. But if some compact states withdrew and others did not, that would leave the convention in the hands of a non-compact states and the compact states that did not withdraw. Or the convention might decide to seat other delegates. The bill provides that the 3 delegates from each state would be the governor, the Speaker of the House, and the President pro tem of the Senate. No state would be free to select any other delegates. Does this mean non-member states are free to select delegates in other ways, but compact states are bound by this provision? The bill provides that if any delegate violates any provision of the compact, then every delegate from that state forfeits his appointment and must return to the state capital. That would leave the state unrepresented. The bill provides that every delegate shall take temporary leave of his state office while the convention is in session. This will leave 50 states without a governor, speaker, or president pro tem, all at the same time. Good time for terrorists to strike. The bill provides that by entering into this compact, the state is considered to have ratified the balanced budget amendment if that amendment is adopted by the convention. This is clearly contrary to Article 5, which contemplates that after a convention adopts an amendment, the states will deliberate again to determine whether that amendment was really a wise idea. The bill eliminates this last stage of deliberation. I'm confident the court would consider this to violate both the letter and the spirit of Article 5. In short, I consider this bill to be a genuine and sincere attempt to limit a convention to a balanced budget amendment. Without this bill, an Article 5 convention would be a Pandora's box of difficulties. Unfortunately, this bill opens a whole new Pandora's box without completely closing the old one. And I'd like to also say that though Andy Schlafly did participate for 4 months in writing this, when it was over, he assumed a neutral stance on it. So if I could leave this with you, those
Please
are the
do, Ms.
statements.
Detweiler. Thank you.
Thank
All
you
right.
very much.
We have no one else signed up to speak to the committee unless there is someone who hasn't signed up wish to do so. If not, we will close the further public input to House Bill 794. It's now in the breast of the committee. Do we have a motion? Motion is due pass by Mr. Lindsay, seconded by Mr. Jacobs. We have discussion or amendments on the motion. Are there any discussions or amendments? If not, the chair will call for the question. All in favor signify by saying aye. Aye. Opposed, like sign.
No.
Chair moves that the ayes have it, and the bill passes the committee with favorable recommendation. Mr. Bruce, that's yours.
Yeah. Just a point of order, because I think something as serious as this, I'm not sure what the rules of this committee are, but
You have to make a motion to overrule the chair.
Well, I'm not trying to overrule you. I'm asking that we have a hand vote or something that signifies.
I've called for a vote, took a normal vote, as we usually do, unless there is doubt in the mind of the chair as to that vote. I did not have any doubt at this point. If you are dissatisfied with my ruling and decision, you have to make a motion to overrule the chair.
Okay. Well, I make such a motion that we have a hand vote, so that everybody's vote is on record, or however we do it.
Motion's out of order. I've just stated to you what is required would be to have a motion to overrule the decision of the chair.
Okay. So, and then we go to the next step. Is that what we're saying?
Yeah. Then,
okay. Well, I'd like to make a motion.
Then you, if that prevails, then you can make a motion at that time for there to be a hand vote as opposed to a voice vote.
Okay.
And if that passes, there would be then a hand vote.
Okay.
The chair normally decides the form of vote, and then if the chair is in doubt, the chair will call for a different form of vote.
Okay.
All right.
Okay. With all due respect, then I challenge the vote, as you just stated.
Yes,
the motion.
You're making a motion to
I move to
overrule
overrule
the chair. All right. Motion made and seconded. Any discussion on the motion? If not, the chair calls for a vote on the motion, and as usual, the chair will call for a voice vote. If you want to challenge that, you have a right to do so. The vote is to overrule the ruling of the chair as to the taking of a voice vote on the last motion. All those in favor of overruling the chair signify by saying aye.
Aye.
All those opposed, you're very loud. I'm going to turn your mic off for that. All those opposed to overruling the chair signify by saying aye. Aye. The chair rules that the motion to overrule the chair fails. All right. I will take a brief break, about 2 or 3 minutes, to allow those who are here strictly on the bills we previously have had to go ahead and vacate the room, and then we'll go to the next bill. House Bill 108, House Resolution 108. Excuse me.
Legislator would be is, are we passing state legislation that's going to be held unconstitutional as violating, because there's federal law that's going to trump it.
And passing legislation, we're passing a constitutional
amendment
proposal.
Right, but that we don't want to have a conflict with federal law. We don't want to have Attorney General Sam Owens defending and spending state money and resources on something that is, to use my words, a fool's errand. And so I want to know a little bit more about what's been going on in these other states. You mentioned that 5 states had passed laws. Are you saying that in all 5 of those states there's been a constitutional challenge that's been where the state has won their challenge?
Let me go back to the first part of your question. As a fiscal conservative, I've absolutely looked at it through those eyes. Let me look at it through a little bit of a different angle, a baseball player's eyes. 0 for 5 the NLRB is. I would expect that nobody would challenge and be 0 for 6 against what this constitutional amendment has created in those other states. I've met with the Attorney General. There is no reason for me to assume that there would be a lawsuit against this. It has been upheld 5 times, And I couldn't imagine somebody wanting to spend the effort, time, and energy and money to then sue once for 6 times. So 0 for 5 in my book is a rough night.
What's been upheld 5 times?
But that's my question. Has it been?
They have been challenged in federal court by the NLRB.
What has been
The
challenged?
constitutionality of this secret ballot
The
amendment.
same language?
Verbatim.
And 5 states have passed this and have it verbatim as you have here, and it's been upheld?
Yes, sir.
What are those
For
5
Mr. Chairman.
states?
They are Alabama, South Carolina, Utah, South Dakota, and Arizona.
Alabama, South Carolina, Utah.
Alabama, South Carolina, Utah, South Dakota, and Arizona.
Okay. And they have the same language you're talking about we have here.
Yes, sir, to the best of my knowledge.
What I asked you said they were verbatim. Now, is it something you know or don't know?
I do know.
You do know.
Mr. Chairman.
Hold on, let me finish.
Sorry.
Please. Is
It's
it
to your
the exact
question,
same
sorry.
language that's been proposed here, that's been enacted by those 5 states and upheld by their courts as a constitutional amendment?
To the best of my knowledge and per legislative council.
Okay. All right. Go ahead, please.
And Mr. Chairman, I apologize. I just was able to speak to your question. Is the case you're referring to that upheld the Arizona state law as constitutional? Are you referring to NLRB versus Arizona 212 Westlaw 3848400 decided on September 5th, 2012?
I'm a builder. I'm not an attorney. So that sounded like you just picked tonight's lottery numbers.
I didn't. And
if you could supply to me the case, do you have the case law in front of you?
I have it right here. You're testifying, and we're trying to decide as responsible legislators whether we should pass this bill, and I'm asking you questions that go to my understanding to allow me to make that decision. And I really, with all due respect, I do not appreciate you throwing it back to me and saying that I'm asking a question about lottery numbers. I apologize. I apologize.
Do you have an answer to her question? If you don't, we'll move on to another question.
I do not, sir.
All right.
Thank you.
Any further questions you have?
I just debate at the appropriate time.
Thank you. All right, let's see. Come back to this side, I believe.
Point of order, Mr. Chairman. Point of order, Mr. Chairman.
Certainly.
Just out of curiosity, Mr. Chairman, I know that the majority caucus has a meeting at 4 today, and I didn't know the chair would attend.
We're running short.
We had in front of them, so I'm
Thank you. We are going to probably have to.
I've been missing an appropriations committee for an hour, which is important to me.
Yeah. Understood. We do have other meetings, but there is a full caucus meeting for some reason this afternoon. We may suspend at 4 o'clock and come back. Today being Tuesday, perhaps we'll take it up Thursday. Over here to this side, we have who is it?
We don't have a call. I just said
I don't have a problem. All you have to do is take a. All you have to do, Mr. Baber, is take a pledge. No problem. All right. Any questions? You have a question? Excuse me. Go ahead. You got it.
Mr. Chairman, if my lottery statement was a little bit out of character for this room, I would say that Representative Mabers was too,
we
and
joke
very
among
funny,
ourselves.
very funny.
Go ahead.
Mr. Chairman, my good friend, Mr. Duncan, Representative Duncan, I have a couple of questions. The first question, and it may be more appropriate to Ms. Travis, this bill or this resolution would change Section 1 of the Constitution. Section 1 is the section in which we talk about our basic rights. Section 2 talks about elections. So are you intending this to be an election issue or a civil rights issue?
I would refer to legislative counsel to answer that question without. I wouldn't want to answer it out of turn. As I understand it, Section 2 is the actual ballot question that shows up, and that is something that has got to be approved in the same piece of legislation that goes forward, the same constitutional amendment.
Yes, ma'am.
It also refers to, in this section, that where there's local, state, or federal law that requires it. So we already have, actually back up, the Constitution already provides in Section 2 the right for secret ballot for all other elections, correct?
Repeat the question.
So right now, your bill is discussing both elections, regular elections where we're voted on.
That's correct.
As well as elections
That's correct.
But we already have in one section, in section 2, the right to secret ballot for our regular elections.
Section 2 is the proposed question.
No, not, I'm sorry, not section 2 of your bill. Excuse me, I'm not being clear. Section 2 of the Constitution.
Okay.
Section 2 of the Constitution currently gives the exact same right to secret ballot. Excuse me, one second. Method of voting, paragraph 1, elections by the people shall be by secret ballot and shall be conducted in accordance with the procedures provided by law. So that's already covered in our law. Is that fair to say?
As the lady so states.
So really the only thing that we would be changing is requiring that the same secret ballot would apply for union elections. Is that correct?
I wouldn't necessarily say that. I don't necessarily agree that every vote is constitutionally guaranteed.
All right. Thank you, ma'am. Next, we're going to try to speed up a little bit. Do we have another? Is Ms. Lindsay's your button pushed? No, thank you. And we have Ms. Oliver. Thank you.
The right to have a paper check ballot is determined by the employer. Is that correct?
I'm unsure. I am unsure.
I think I'm right about that. Somebody else will correct me if I'm not.
Okay.
This bill is not supported, or it's not part of the legislative agenda of the Chamber of Commerce, is it?
Georgia Chamber just met me outside the hall and said that I could be used in a matter of testimony.
It wasn't
that they
part
do
of their
support it.
legislative agenda in the beginning of this session. And AT&T is not supporting this bill.
Not that I'm aware
Is
of.
there a single employer in Georgia that is going to stand up and support this bill so to take away their right to determine a paper election for employees?
I'm unsure of that answer, but that wouldn't be my motivation to carry legislation forward.
Just trying to figure out who wants this bill.
I think going back to my initial comments, the folks in the 26th district are extremely supportive of this bill, and that's who I ultimately am elected by.
You have talked a lot about a secret ballot, and I forgive me for my confusion at the subcommittee. I really didn't know 2/3 through that you were talking about a union election. I couldn't figure out what secret ballot you were talking about. But now that I understand it, employers have a right to accept an alternative form of election of unions, and that's what you want to do away with because you don't deem that a secret ballot.
Repeat that question, the tail end.
It's the employer right that you're trying to do away with it, that you don't believe they should have the choice of a paper ballot.
No, we'll go back to the basic statement, and I apologize to be boring and repetitive to this, but the sole intent is to protect the right of the individual's ability to cast a ballot secretly.
How many
That's it.
ballots of paper ballots have been conducted in Georgia in the last 10 years that have formed a union?
Not certain I'd be able to have that information at the edge of my fingertips right now.
And you said that there were 5 states that have passed this, and you also said there were 5 courts that have upheld it. I've only seen one court decision. Are there more? Is there more than one court decision?
Actually, if I go back to my testimony, I think there were. My response was 5 states have passed this. Several have been challenged.
Okay.
So,
There's only one court decision. Is that correct?
I'm not certain of that.
Okay. So if I was confused. There are not 5 courts that have upheld.
Absolutely, and the testimony
Okay.
does not show that.
Okay. Thank you.
Yes, ma'am.
Anything further from members of the committee? Let me conclude with a couple of things that I want you to address. The initiative you have here is by a constitutional amendment. Why are we looking at that as opposed to legislation? Bill, a statute.
Yeah, I met with Legislative Counsel last year, actually, is when I sat down one-on-one, and this was the best recommendation that they came to me with. To protect this, they went through case law, a lot of what I think the cases that you guys have talked about, that they went back to, this is really the only way, because there's a mesh, as you'll hear in additional testimony, there's a mesh between federal law and state law here, and that's what makes this complicated. And so this is the best suggestion that they gave us looking forward.
2 other things. One is, even were the constitutional amendment to pass, if there is to be a recognition by the National Labor Relations Board as to the right of what you call, is it the card
check.
Card check. Do you believe that decision of NLRB would override what we would do in the constitutional amendment?
To answer that question, I went to go meet with Attorney General Sam Olens, and I think he felt like this was worthy of a challenge, that he felt like it would supersede it.
I don't dispute what may be the Attorney General's thoughts about it, but I think federal law would override what we're doing by this constitutional amendment, perhaps. That's my position on it. But the other thing that worries me the most about it is a constitutional amendment is a irrevocable decision which has sometimes unintended consequences. As I read the proposed provision for the amendment, I believe everything that is being done by any group or body, including public office holders, such as legislators, if one legislator says, I want my ballot to be secret, they would be able to require that board taken down and actual secret ballots made as to voting that we do on a day-to-day basis. That's an unintended consequence I see coming out of this particular amendment. Has that been thought through with what may happen?
Yes, sir. Yes, Mr. Chairman, absolutely. And I think I keep coming back to that person that wants their vote to be known, whether it be prior to walking in or afterwards, still has the absolute freedom of expression. It just may not be on a forum that is up for because there's no way to protect that individual that doesn't want it out for public consumption.
But one person would decide for the entire House that all votes be made private, that we don't have the ability to put our votes up on a board anymore as we do today, because it says public office, public votes shall be by secret ballot. I mean, there's no limitation to that.
Right.
And I think that's where it would have to be viewed if a court looked at it and somebody says, I don't want my vote recorded as being a public vote in the House or the Senate.
And that would be fine for me because I think that's the way the Senate does it right now.
No, it's public.
The Senate's open for it's secret.
They've got the. It just, we don't do.
It's delayed, is what I'm saying. Is at the same time.
That is to me a very valid concern with what we're trying to do here, and I don't think it's been thought through as far as what we're seeking to accomplish. With that said, I think we're going to be having the chair is going to rule that the committee meeting must come to a conclusion for today. We will adjourn to meet on Thursday at 2 o'clock, and we'll take your matter up first.
Thank you, Mr. Chairman.
Thank you.
Oh, there you go. Yeah, if you.